There it is. Sorry. Nope, all good. All right, ma'am, are you Lee Coney?
Yes.
And so we've got two cases here. We've got 25 DCCR 1274, which is a new offense. And then there is 24 DCCR 1600, which is an MTRP. We were previously here in the motion to revoke case. And we were set for a hearing this afternoon. And Miss Coney, was previously here. It entered pleas of true to count 3, 4, 6, and 7. Got an updated pre-sentence report. First of all, have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, we have.
Okay, any additions or corrections to that?
No, Your Honor.
Not from the sentence.
And so what I'll do is let's go through the new case since there's an agreement, and then I'll go through the sentencing and that MTRP so that I know exactly what's going on. And will she waive the formal reading of the indictment in the new case?
So moved.
Miss Coney, in cause number 25, DCCR 1274, you're charged with the state jail felony offense of possession of a controlled substance from September 12th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them? And do you understand if I follow this agreement that you will be waiving or giving up any right to appeal?
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
And it looks like the agreement that you've reached is for a 20-month term in the state jail prison. And the state would run concurrently with that motion to revoke case in cause number 24, DCCR 1600. Also, the state has agreed not to file cases that are that have been, I guess, received but not filed yet on an offense date of November 1st of 2025. Is that
They
correct?
have not yet been received, Your Honor. The
Okay.
labs are pending.
Okay, same types of offenses.
Yes.
Your own offenses.
Yeah.
All right. Is that your understanding of the agreement?
If-
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Miss Coney is not competent?
None that I'm aware of, Your Honor.
All right, ma'am. In cause number 25, DCCR 1274, I find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with that agreement to a term of 20 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And so then there was no agreement in cause number 24, DCCR 1600. Is it the, I guess, recommendation at this time that I sentence her in accordance with what that plea was?
Yes, Your Honor.
So the 20 months would
20
be
months concurrent with 1274 and refuse the 2, which I anticipate to be state jail and Class A.
Okay. All right, then, based on that, then Ms. Coney in cause number 24, DCCR 1600. Well, let me ask you, initially this was unagreed, and so there was a right to appeal, but it sounds like there's now an agreement and some things that the state has done and given, I guess, in exchange for that. And so is it your understanding, and do you want me to follow that agreement now for a 20-month term in that motion to revoke it?
That's correct, Your Honor. She waives appeal.
So I am going to have you sign a document that shows that this is now a plea bargain, and so you've waived your right to appeal, and then I'll go forward.
So. Let's see. No,
All right, so then I'm going to find that you entered your pleas of true to counts 3, 4, 6, and 7 freely and voluntarily. Find those counts true, and at this time find sufficient evidence to find you guilty and find you guilty of theft of property. Sentence you in accordance with this new agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run together consecutively at the same time. The state agrees in both of those, not concurrently, I'm sorry, concurrently. So they will run at the same time. And the state will agree to refuse the two cases from November 11th of 2025. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed. And so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right, thank you. Good luck to you, ma'am. Thank you, Mr. Kimler. Thank you, Ms. French, for y'all discussing that and working it out. Just reset it to next week. We're gonna reset, Mr. Coleman. Mr. Adams is unable to be here this morning on John Lamel, so we'll reset John Lamel. All right, good morning, sir. You're Lenny Ledette. Ledette, I'm sorry. And Mr. Ledette's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Thanks, ready, Your Honor.
Judge, we're ready subject to the case that I have set in another county, and I've spoken with him about it.
All right, so I'm going to contact that county, kind of see where we stand after this. I want to make sure we're all on the same page because after today, there won't be any plea negotiations or agreements. And it looks, have there been any new negotiations or?
Yes, Your Honor. Last week I filed a notice of enhancement using his prior to enhance if he's convicted of this offense, his punishment range will be that of a first degree. So at that time, I made an offer for him to plea open to a second degree, just under the indictment count 1.
All right.
And I believe that's been rejected.
And it looks like that prior that Mr. Nichols filed is regarding an aggravated robbery from September.
Quick pause here. Jaden Simon is facing aggravated robbery, which is far more serious than regular robbery and usually means a weapon or threat was involved. The prosecution already offered a 20-year plea deal, but he rejected it. That's a huge gamble because once this goes to trial, the potential sentence could be much higher in Interview 1.
September 27th of 1997. And so I'm sure Mr. LeBlanc has gone over with you, Mr. Ledette, that if you're found guilty in this case and that prior conviction is true, that would enhance your punishment to that of a first degree felony, which is between 5 years and up to 99 years or life in prison. You understand?
Yeah.
And do you want to reject that and go forward with your trial?
Yes.
All right, I am going to number this case, the number 1 case. It's obviously the oldest. Mr. Ledette's in custody. It's time to get it moving. I will contact Judge Thomas and see how, if we can work that out, and we'll let you know today between he and I and who kind of wins out on that one. Okay. So we'll do our best to get your case tried next week. All of who gets which attorney depends on the type of case, age of the case, if the defendant's in custody, and all kinds of things. So I'll talk to Judge Thomas and we'll get that figured out today. Well, if Judge Thomas wins, depending on age of case and type of case, then yes, there would have to be a reset because Mr. LeBlanc can only be in one court at a time. If I win, then we get them and we try your case next week. So we'll find that out today. I'll talk with Judge Thomas. I'll do the best I can. I'll want your case tried this next week as badly probably as anyone. It's one of the oldest on my docket, so it's time to get it taken care of, obviously. So I will do my best to get Mr. LeBlanc here next week, and we'll know that today. Okay? All right, go
Thank
back
you.
with the bailiff.
And that decision right there changes everything. By rejecting the deal, Simon is now heading toward a full trial. If he's convicted on both charges, the judge could stack the sentences, meaning the time could be served one after another. That makes this a very high-stakes gamble.